Good morning, everybody. So as Heather said, my name's Nicole Johnson. I'm a Senior Associate with the employment team at Hempsons. I'm based in the London office. I appreciate there's quite a few of sort of similar sessions floating around at the moment, and that's understandable. There's a lot that's happened this year as regards employment legislation updates, case law updates. And as we sort of bring the year to a close, it is helpful to sort of look back and reflect on what's happened and also what that means going into 2026. So thank you all for taking the time to join the Hempson session. What we're offering is really a bit of a whistle-stop tour, if you like, as to the current position in relation to the Employment Rights Bill. A review of the cases that have come up this year, or that have, in terms of the impact where that's landed this year. A little bit of an immigration update as well in light of those changes, and ideally a little bit of time at the end for Q&A. So please do pop any queries that you might have in the chat. I'm hopeful that I might try and address them in the course of the talk, but if not, we'll try and address them there. So when looking at the Employment Rights Bill itself, I'm sure you're thinking, Nicole, come on. We've heard about this all already, and I'm sure you have. What I anticipate, though, is that there is probably a breadth of knowledge as to what the bill actually covers when it's coming into force, and what that might mean practically for you when looking at management of your own teams and support of your own organisations. So the Employment Rights Bill itself really was led following the Labour election promises that they were going to introduce wide sweeping and fundamental reform to employment law once they came into power. The bill itself was published in October of last year, and contrary to their original sort of 100 days pledge, it's taken significantly longer than expected, and there's been significant slippage in trying to get it enacted and enforced. So in terms of the primary question which we get at the moment, which is it expected to pass shortly? It was, but unfortunately it's reached a point within Parliament where it has stalled. There was meant to be sort of final agreement as at last month, but unfortunately there are points of dispute between the houses, which mean in effect it's sort of ping-ponging back and forth between them whilst they try to hammer out the points of dispute where they're not agreed. October's also seen a series of consultations around proposed changes that have been released around proposals and amendments that would come out of the bill. So there's lots going on. But it is, once enacted, going to be the largest reform of UK employment law in years. And we've put on one of the bullet points there for you just some of the areas that are likely to be affected. There's a couple that I'm going to pick out in a few of my slides later on, but just so you know, those are some of the areas that will be affected. So as at this month, around the 17th, the bill was again debated. It was back and forth between the House of Lords and the Commons, and the key sort of changes that were really up for discussion at that point were around the 0 hours contracts, the decision to retain the 50% turnout thresholds for trade unions around striking and balloting, but their primary disagreement is around day one rights in relation to unfair dismissal. In short, I'm going to give that really annoying lawyer's answer of when is this all going to sort of come into effect? We don't quite yet know. We'll have to wait and see. If you are picking up that there are timings around when certain elements of the bill will be enforced, those are indicative, and it really does depend on the commencement orders as to when those will then take effect. So whilst we can't tell you very much around when exactly things will come into force, we thought it might still be helpful for us to just talk through a little bit about some of the key or headline changes that we know are likely to be coming our way. So as I mentioned, that the sort of, the biggie is unfair dismissal. And currently you have to be employed for 2 years to be eligible to bring a claim of unfair dismissal in most cases. The government had pledged that they were going to make unfair dismissal a day one right by removing the 2-year qualifying period. The government's preference is to allow employers to operate something of a probationary period extended, maybe up to 9 months, during which they would then apply something more akin to a light touch dismissal procedure. However, the Lords are insisting that there should be a qualifying period of at least 6 months. Currently, that's the position that they're holding, and that's the gap that can't yet be breached. The Commons aren't currently willing to agree that, because of course it runs contrary to Labour's original pledge during the election and their manifesto, and so they're really keen, given that was their flagship argument, that that one be pushed through. So that's the point of contention at the minute. Predictable working. So the bill originally placed an obligation on employers to offer guaranteed hours contracts. So instead, the House of Lords have amended that bill, whereby employers would notify workers of the right to have guaranteed hours contracts. And if the individual declines the offer, they can then opt out of receiving further offers. But at the minute, there's a dispute around that. There's also a dispute around seasonal working. What are the provisions that are going to relate to that, and how is seasonal working even defined? So lots going on there. There's a couple of other bullet points also just around reasonable notice of shifts and pay for late cancellation. So it's very much around supporting the individuals and not seeing them lose out or be put at a detriment because they are working sort of 0-hour type contracts. Fire and rehire, we've also popped a point on the slide for you there. That's going to be curtailed, except where there is organisational survival that's at risk, so that the threshold is significantly higher for you to be able to fire and rehire. And they've also proposed changes in relation to collective redundancy. So currently, a protective award is a penalty awarded by the Employment Tribunal against an employer for not complying with collective redundancy consultation requirements. A bit of a mouthful. So that is a change that may not affect you unless you've potentially done something wrong. Under the bill, the proposal is going to be that the maximum protective award for failing to collectively consult on redundancies would go from the 90 days to 180 days pay, which is what we've popped on the slide. And in effect, what they are trying to ensure is that employers don't benefit, whether as a matter of ease or financially, from not complying with their obligations as regards collective consultation and redundancy. So it's going to mean practically that you will need to ensure that you are on top of your processes, that you are following the expected rules and timelines, and being as transparent and fair as possible within those processes. Otherwise, it is going to be significantly more expensive as an exercise. Just on the next slide, I've also flagged for you just industrial action. So in relation to that, on the day that the bill is passed, it will repeal minimum service levels, and that removes the government's ability to define what minimum service levels must be maintained during industrial action across a range of public services. So that includes health, education, fire. Employers in those sectors would no longer be able to issue work notices requiring certain individuals to attend work during strike action. So as a result, industrial action is likely to have greater operational and reputational impact for those public services. When looking then also at key changes that take place 2 months after royal assent's given, currently the indication is that will apply to the balloting thresholds. So industrial action will be lawful if supported by a simple majority of votes cast. Currently, for key public services, it's also necessary for at least 40% of those entitled to vote in favour. And that requirement would be removed. We're also looking at notice periods that would be in effect 2 months after royal assent. So unions would be required to give 10 days notice of employers of their intention to strike as opposed to 14 days. At the same time, the period with which a ballot ceases to be effective, it's currently 6 months subject to extension by agreement. That will be increased to 12 months. And there's also a proposal to reduce the level of information that must be provided in the ballot and in industrial action notices. So there's a lot going on there that we'll need to be on top of once these changes come into play, if industrial action is something that is impacting on your organisation. The trade union landscape in particular is one of those areas that is arguably going to be made simpler in terms of unions gaining recognition, securing workplace access, and certainly, obviously, their ability to initiate industrial action. So whilst that might not seem great for employers, there is arguably some simplicity that these changes provide to processes that might make might streamline processes for employers. So possibly not all doom and gloom, but something to keep an eye on. I've included for you also a bullet point on sick pay and family leave. They are, effectively what they say, the intention to offer statutory sick pay from day one and no low earnings limits, day one paternity and unpaid parental leave, new bereavement leave, and also stronger pregnancy protection. So lots to think about there and how that might impact your organisation. Tribunal time limits are also potentially going to be increased. So currently the expectation is that you would bring your claim within 3 months of the act complained of, whether failure to act or an act itself. The proposal is that will go up to 6 months, which extends, of course, the time where people can bring claims and creates, extended liability for employers. There's also the proposal of the creation of a Fair Work agency to enforce pay and leave rights. So they really are looking at this not just in terms of what rules they can change, but also enforcement around some of the rights that are going to be affected by the changes in this bill. I've then included a slide just on the impact of the proposed changes, so around the use of bank and agency, the need to have a better grasp on how you are using bank and agency. So do we need to use them at all? But also where we do, and we might need to make short notice changes, what's in place to support that, particularly given some of the rules that will be coming into force and the cost consequences arising out of that. There are fewer options to change terms where agreement's not reached. That's going to be much more difficult. As we've discussed, more stringent collective consultation requirements, greater emphasis on the use of probation and performance management, keeping of performance records, particularly where those might need to lead to early dismissals. the likely increase in employment tribunal claims. So the reality is that you will end up with claims being submitted much later, potentially after staff have left, that you would want to call on as witnesses and managers, and memories having faded. So it just makes management around anticipation of claims and how to sort of work towards those, it can be significantly much more challenging. And obviously there's a lot of change in relation to industrial action that's proposed. Actions that you can be taking now will, we suggest, include pause of major policy rewrites, mainly because all you could end up doing is writing a policy that you're then going to have to amend further and rewrite shortly after the act is enacted. The hotspots that you might want to consider will include bank rostering, variable hours, use of variable hours contracts, change programs in terms of the timing, the areas of work that will be impacted, selection, and also the use of probation earlier, particularly if unfair dismissal is going to be a day one right. So ensuring that you've got a clear sense of whether or not you're happy that somebody is performing at the level that you need them to, so that if not, you are as quickly as possible fairly but robustly building your case in the event that you may need to terminate their employment to either avoid, claims that and or complaints that might come your way, and or to minimise prospects of any such complaints succeeding. So as we've pointed out, they're just tightening up probation and performance processes and your record keeping. I do a lot of employment litigation work, and one of the things that we find in terms of the difference between a successful outcome is document keeping, record keeping. When it's down to a he said, she said, quite often it's the contemporaneous documents that will inform tribunal decision as to whether or not to uphold a claim or not. And that can be much more difficult if you've had to wait 6 months for a claim. We've all encountered that scenario where you're looking for that contract or that outcome letter or that very short email that, where we definitely discussed that thing with the employee that we now can't find. Those are the documents that are going to be central to your ability to robustly manage your processes going forward and to help you to sort of knock back challenges where they come. And that can be difficult if you're having to wait 6 months for a claim to come in. You might want to think about protocols around storage of certain documents. Is there ability to keep people's email accounts open or available, perhaps to a senior manager or IT, in case we need to do searches of those accounts after managers or other staff have left that might have knowledge of what's being complained of. Those are things that you might want to start keeping a focus on, particularly in relation to your record keeping. You might want to review dispute resolution routes. So where we know that it's going to be increasingly likely that claim volume will increase and complaint volume will increase. Is it worth investing in processes that enable you to de-escalate before you get to that stage, saving both time and managerial time, but also cost? And then also plan around training for your managers and HR on the new rights and enforcement once they are enacted and come into play. Once people are aware of what the changes are and what's happening, they're much better able to respond to them and to ensure they're not falling foul of those changes inadvertently. So there's quite a lot to think about. And as we've said, unfortunately, we don't yet have a clear steer on when everything is going to be in force. It's very much a case of watch this space. But realistically, you are looking, I would have thought, towards the back end of 2026, possibly even 2027 for some of these changes, once agreement is reached within Parliament. I'm going to move on now just to some case law developments. I couldn't really do this section for 2025 without reference to For Women Scotland, which is quite a big case, and strikingly, there is a lot that in terms of the reporting on this case and the noise around this case that was very topical at the time. But when looking at the fallout, is it as significant as was originally expected? I think is probably one of the questions that's fair for people to ask. So for Women Scotland, the case itself came about as a result of a 2018 initiative by the Scottish Government to improve female representation on public boards. So that initiative gave rise to the Gender Representation on Public Boards Act of 2018, and that required positive action to be taken to address gender imbalances on public sector boards in Scotland, and it also gave rise to associated statutory guidance. So all of that together stated that transgender women in the gender recognition certificate were to be legally classed as women, in accordance with the Gender Recognition Act of 2004 and the Equality Act. And this would have meant that transgender women with a certificate would have been included in the figures for female representation on public boards. And it would also have given those individuals the right to use female single-sex services and spaces. So it was potentially far-reaching, and the case centred on the legal definition. What's the legal definition of women or a woman under the Equality Act? And it really encapsulates the very high tension between sort of the gender critical position and the transgender rights position, and the balance that needed to be struck. So it was judicially reviewed, went up to the Supreme Court, and they unanimously decided that trans individuals, even where they have a gender certificate, should not be treated as being of their acquired gender for the purposes of the relevant sections of the Equality Act when referring to a person's sex. And according to that judgment, the Equality Act, under the Equality Act, man means biological man and woman means biological woman. An appeal was allowed. So albeit the Supreme Court had made a decision of the finding around the interpretation in relation to sex, certified sex would produce what they thought was an unworkable, I'll read their words, unworkable, impractical, anomalous or illogical results, and it's unlikely to be intended to be that was what was intended by the legislature. So that was their view, and it was really a sort of drill down into what is the meaning of the words man and woman. The appeal was allowed. So when you're looking at sex, and in particular section 9(1), for all purposes is displaced where you needed to keep the Equality Act coherent in order for it to be workable effectively, is what they said. And where the case has sort of been picked up is around what that now means practically. So the Equality and Human Rights Commission intervened, and on the 5th of September of this year, they sent a much anticipated code of practice update to the Minister for Women and Equalities for approval. And there's been a bit of back and forth there. They'd updated the code in light of the ruling, and so there's been discussion around where that leads next. There's sort of ongoing debate around the further amendments. I believe the current position is that the EHRC is still waiting to hear from the minister, and there's been a little bit of sniping back and forth about information that should or should not have been provided and delays. But realistically, it's looking like the revised code around practically what this means is going to come into force probably in the new year. But when looking at protections for trans people, there is still protection in place within the Equality Act, and support can be given. I think what employers really are looking for now is the guidance around how they implement this within the workplace in order to ensure that they are treating and supporting everybody fairly, and you're balancing all of the views in as much as you can, albeit respectfully expressed, so that there's no one group that's feeling that they are not being adequately supported within the meaning of the Equality Act. If I move on to Mullinger versus the Ministry of Justice, this is a case where the judgment's really a reminder about the importance of following proper processes, particularly where people have disabilities, ensuring that you are obtaining the relevant medical evidence, consulting with the employer and considering alternatives to dismissal. So in this case, Mr. Mullinger was a Band 3 prison officer, and he'd been diagnosed with epilepsy in 2023. There wasn't any dispute between the parties as to whether or not his epilepsy was a disability. That was agreed. But following his diagnosis, there arose concerns around security risk, particularly if he were to have a seizure whilst at work, both in respect of prisoners, but also other staff, if he wasn't able to react, but also if he needed care and their attention was drawn to him. And so he was placed on restricted duties. Occupational health advice had been that he needed to have some form of periodic break that was routine, and he'd had significant periods of sickness absence, but was later dismissed following attempts at restricted duties. He was dismissed without prior warning for high sickness record and the unlikelihood of him being able to ever return to his full duties. And so we've put on the slide just a couple of bullet points around some of the sort of key notes in relation to how his sickness absence was managed. He was dismissed in March of 2023. So as you can see, they're also a very quick turnaround between when he's diagnosed and the decision to dismiss, which in and of itself doesn't indicate that much thought was being given to alternatives that might allow them to keep him employed or adjustments. And he appealed, but that appeal was dismissed in May of 2023. So the ET was very critical when this case got to tribunal, was very critical that there hadn't really been proper inquiry into his medical position, and that led to unreasonable assumptions being made about what he could and couldn't do. A lack of real understanding, I suppose, in relation to the symptoms that he was experiencing. Could they have stabilised, possibly with medication, or allowing him to return part-time to full, albeit full duties or light duties on a full-time basis? There wasn't really much that was explored in order to see what could have been done to support him. Might we have considered temporary redeployment to an admin post to allow him time to come to terms with the diagnosis and how best to manage it himself? And the claimant there pursued complaints of disability discrimination, unsurprisingly, but also unfair dismissal. And the tribunal found that the employer, the Ministry of Justice, had failed to properly follow attendance management policy. They're also critical of them for not exploring alternatives to dismissal, properly consulting with him before dismissing him or looking at redeployment options. And unfortunately for the Ministry of Justice, that the management of that process was particularly costly. As you'll see, the claimant was awarded just shy of £500,000. So there is benefit to trying to support people in as much as you can, giving them the leeway where at all possible, in order to avoid running the risk of a similar finding and level of remedy being awarded. If I move on to the AB Grafters Group case, this one's a little bit more straightforward. The individual here worked for a hospitality recruitment agency, and there was an incident where she believed she was due to work, missed the arranged transport, and accepted a lift from a colleague. During that journey, with the colleague CD, he subjected AB, the claimant in this case, to sexual harassment, which included touching and sexual comments and showing her pornographic material. She complained about that behaviour, and that was all investigated as part of an internal process. However, during that process, CD, the employee who offered the claimant the lift and subjected her to harassment, was not called as a witness in order to give his account. There was a police investigation that followed, but there were no charges. And there was a finding that she didn't work the further shifts, and they didn't think there was a liability there. AB took the matter to an employment tribunal alleging sexual harassment under the Equality Act. And so the decision here is really the focus on whether or not you can, as an employer, be liable for acts that effectively were conducted outside the scope of work. So what's the proximity? Has somebody acted inappropriately in the course of their regular duties, or is this so out with what's expected of them that actually, as the employer, you're not going to be held liable? So the ET considered the factual background to this case. They determined that CD, the driver, had sexually harassed the claimant, and they really focused in on this question of whether or not his behaviour was within the course of his employment, which might then mean that the employer was liable. And the tribunal held that he was not acting in the course of employment. He wasn't booked to work at the time. He wasn't required to give the claimant a lift because she'd missed the shuttle. The lift that he gave her wasn't anything that had been arranged or sort of agreed or sanctioned by the employer. They weren't aware of it. This is something that she had agreed directly with him. And in those circumstances, they found that at first instance that his actions, his behaviour were not within the course of conduct, and therefore the employer was not liable. Claim fails. The claimant appealed, and the matter then proceeded to the EAT. And having considered all of the relevant information, the EAT allowed the appeal. Their view was that the tribunal had failed to analyse whether there was sufficient connection between what had happened and the work that these two individuals were employed to do. And so they said the ET should have considered and failed to consider whether or not the harassment was part of a course of conduct linked to work, whether there was a closeness in the connection between CD's role and the circumstances that gave rise to this incident that allowed this harassment to happen, and whether the situation was an extension of the workplace. So it's not to say that it definitely is. What the appeals tribunal is saying is that the first instance tribunal has not considered that. And so accordingly, they've upheld the appeal, but remitted the decision back to the first instance tribunal for reconsideration in light of those points. So it may be the case that they now ask themselves these questions and the result is the same, or they might now find that actually they do think that there is sufficient connection that means that the employer would be liable, but we'll have to wait to see what the outcome of that decision will be. But it's just one to note that even where things happen outside of work, particularly as we're coming into Christmas party season, just because it's not something that we've organised as the employer or that we have immediate knowledge of, doesn't mean that you would avoid liability. So that's another case to be aware of. And just the last case that I'll touch on is the case of Alum versus the Financial Conduct Authority. And in this case, the claimant was employed by the FCA. He was dismissed for gross misconduct in April of 2021 for sending 2 inappropriate emails. The first email was a sort of hostile, anonymous email to a female colleague with whom he'd previously been friends. They'd had an argument at work and she had accused him of stalking her. She gets an anonymous email that evening and it mentioned the stalking, which she assumes, and mentioned other sort of little facts that she thought, you know, only he could really know. So she raises a grievance, and that's reviewed by HR, who then go on to conduct an investigation. Not all of her complaints are upheld. However, despite the claimant's denials that he had anything to do with this, the report concluded that on balance they thought he was the person that had sent the anonymous email. From that basis, they thought it was enough to constitute harassment, contrary to the Equality Act, and that was also in breach of their internal policies around respect at work. There was a second email that was also sent, and it referred to the outcome of a complaint that the claimant himself had made against S, the female employer. And that was also then viewed to be, because of some of the content, considered to be a breach of confidentiality. So in around March 21, the claimant was invited to a disciplinary hearing to consider those allegations of harassment and breach of confidentiality. And following a sort of review of the available evidence, he was summarily dismissed for gross misconduct. He appealed that decision, but was unsuccessful. That matter then proceeded to an employment tribunal in relation to claims for unfair dismissal, race discrimination. The claimant was of British Bangladeshi origin, and he said that his ethnicity impacted on the way in which the disciplinary process was managed. And he also alleged harassment and victimisation. I'll move to the next slide. The employment tribunal at first instance dismissed his case for unfair dismissal, and he appealed against that decision. So the key points to note there are the sort of failure in terms of what the tribunal was interested in. There was a failure to provide interview transcripts. He argued that he hadn't been given the interview transcripts, and that he felt that that meant that the process was unfair because he didn't have full sight as to what was being said. There was also concern about a script that had been prepared by HR in preparation for the disciplinary hearing, and there was a suggestion or a concern that that script meant that the outcome of the process was predetermined. He also complained about searches that his employer had conducted of his work computer, and that he felt that these were a breach of his privacy rights. The ET ended up dismissing all of the claims. The reason very clearly for the dismissal was misconduct. It wasn't that he had raised protected disclosures. There were concerns about breach of confidentiality, and on balance they had determined that he was harassing another colleague, which are perfectly reasonable, if reasonably found, perfectly good reasons to terminate someone's employment that are not connected to them having raised a protected disclosure. They also found that at first instance, the investigation and the disciplinary processes were reasonable, and they were of the view that there was no real evidence of discrimination or victimisation, and the EAT supported the first instance decision. There was a complaint around the delay that it had taken to get the judgment out. I believe it took something like 9 months, but it wasn't determined that that materially impacted on the content of the decision itself. The EAT went further as to say that they felt that the claimant had been given sufficient information, transcripts aren't essential, and that the script itself didn't show prejudgment. I think the things that we would probably sort of caution is that whilst those are the findings in this case, you would still, or we would encourage you to still consider whether or not similar requests into processes that you might be dealing with may be appropriate. So, for example, if somebody has a particular condition, perhaps dyslexia, do we want to offer recordings of meetings? Do we want to offer that transcript where ordinarily we might not? And perhaps we redact sections of it that otherwise we wouldn't disclose, to ensure that that individual has as much opportunity to sort of have access to the relevant information and sort of take it in and be able to put forward a sort of proper defence to the allegations. This script didn't show that HR had prejudged the outcome, but that's not to say all scripts couldn't fall foul of that issue. So if you are preparing scripts, ensuring that it really is about the structure and setting up of the hearing, the meeting, not around sort of finding ways to reinforce previously held beliefs about what the outcome should be in the case. And here, I think, the EAT also said that the computer search didn't affect the fairness of the dismissal. It wasn't relied on as part of the disciplinary decision, so it wasn't something that reasonably he could rely on in relation to the claims that he pursued in the employment tribunal. So helpful decision in terms of giving an example of where things won't count against you, but I don't think you can take it necessarily as a signal that all scripts are fine, or that set ways of dealing with processes are enough. I think you have to look at individuals and tackle them on a case-by-case basis. What are their needs? What does that particular case require you to do? Just moving quickly then on to business immigration. So similar to the Employment Rights Bill, there has been significant change in relation to immigration rules and guidance as of certainly since last year, but also as at this year. We've bullet pointed for you a couple of the sort of key changes and those likely to be impacted. This is an area of certainly, business immigration is an area that we could run, a very lengthy session on, just on its own. So I have compressed quite a few just into the sort of next 5 minutes or so before we go into any Q&A. But as at April of this year, we saw an update to the guidance around certificates of sponsorship, increases in the salary threshold, and changes to the ability to recruit care workers. And I must specify that that's care workers under SOC code 6135 or senior care workers. This will not apply to health and care assistants. They fall under a different code if you sponsor them. A big change that we've seen is also the increase in salary threshold. So if you are wanting to employ somebody via the skilled worker visa route, you need to be able to sponsor them, and the immigration rules require or set out a sort of points-based system that will enable you to do so. Part of that, however, is a requirement that the minimum salary threshold that might apply is going to be 25,000. That's an increase up from 23,300. And so we're finding now that there are lots of roles where previously employers didn't have an issue recruiting to where now suddenly staff are struggling. So, for example, for those that are in the NHS, the healthcare field, the entry-level band 3s outside of London who don't benefit from high-cost area allowance do not now hit the 25,000 salary threshold limit. So that impacts on them. But and I see that somebody's popped up saying that they're a part of a kick. So there are lots of different, that's an example, but there are lots of different roles where that might be of some impact. So we flag that, particularly if you're an organisation that doesn't routinely sponsor, to go and check whether or not roles that you'd previously sponsored without issue, you are still able to sponsor them. One of the other bigger issues is also that you can't pass expenses on to the migrant. Some employers did that before, so there will be certain costs that are held by the sponsor, by the employer, and other costs that are held by the individual, by the applicant, the migrant. And some employers were passing some of their costs or expenses onto the migrant. The change in rules now say that that's something that you cannot do. Overall, the rules then also became much more stringent following the publication of the white paper in May. So this was something that I think across immigration sort of practitioners or those that sort of follow immigration law, the white paper was something that was anticipated. It was something we thought was due to come out sort of towards the back end of summer. And then post the election results that obviously were leaning slightly more in favour of reform and concerns around management of immigration and immigration policy. Quite quickly off the back of that, we saw the immigration white paper that was published in May of 2025, flagging additional changes that would be coming in, including the replacement of the immigration salary list with the temporary shortage list, increase of a skills threshold, which would make it more difficult to employ certain roles if they don't hit a graduate level after a certain period. There's also a proposal to include a 3-year transition period for social care roles to apply to new applications or those who are switching in from other routes. significant changes to the graduate visa route. So where previously you would be looking at a 2-year visa, there's a proposal that would now come down to 18 months, and it being increasingly more difficult for you to sort of switch out of that role. There's also been restrictions on certain routes and their ability to have dependents with them. And a biggie, I think, is also the discussion around requiring migrants to have been here for up to 10 years before they're in a position to apply for indefinite leave to remain. That in particular is one that we can see is going to be particularly challenging, where people are hoping to come here, build a life here, and understandably they would want their families here. The idea that you might have to do that now for 10 years is, we anticipate, going to impact greatly on the ability to recruit and also retain staff, where they may be subject to slightly more stringent immigration rules around their ability to work, particularly if they're sponsored. In terms of considerations in relation to those immigration changes, the main thing is about fairness and consistency, ensuring that you're up to date with the rules and what they mean for you practically. What can you and can't you do? Are your right to work checks up to date? But the knowledge that if you need to, in light of all of this, potentially terminate someone's employment, unfortunately, that you're doing it in as fair a way as possible. Might you want to think about additional pastoral care and compliance with the systems, because the ability to sponsor is not a given. It's not a right. But once you have it, there are many obligations on you, and it can be taken away. We know that compliance checks are up, and that UKVI is willing and prepared to issue civil penalty notices, and the cost of that has also gone up. We're looking at a client at the minute who's experiencing first time breach, and that's resulted in a sort of £45,000 penalty notice, civil penalty notice. So it's expensive if you get it wrong. Those are the significant implications, both potentially civil and criminal. Management of that really is going to revolve around audits, record keeping. Again, sorry if I feel like I'm parroting the same points again, but record keeping is significant. It informs your ability to answer on demand any questions that UKVI might have, and has the scope to even reduce the level of civil penalty that you might receive if all of your systems are in place. And it just so happens that there's another element of the process that you've got wrong that might be a factor in their consideration as to whether or not they're willing to reduce the level of fine that you've been awarded. But also workforce planning and budgeting. It's increasingly becoming more and more expensive to sponsor in particular, but that was the intention, to make it more challenging, make it more expensive, and almost to deter people from sponsoring migrants unless it's necessary, but to ensure that where they do so, they're doing so fairly. But of course that's going to impact on workforce planning when looking at particularly graduates, those on the graduate route that ordinarily might have swapped into the skilled worker route. That's now particularly a challenging area, and we're seeing a lot of challenge there because people aren't meeting the relevant salary thresholds, and are going to have difficulty when it's about the transfer over. So lots more changes to come. We don't think that's the end of it at all by any means, and routinely updates around immigration happen in or around sort of May, April and November to the rules. So it's something that we'll have to keep an eye on, and that you really should be ensuring your teams are up to speed with. If not, do reach out, get the support that's needed, because it's much better to do that than to find after the fact that you know, there's part of the process that's got wrong that you can't then correct. And that's it.
Thank you, Nicole. Thank you for that. As you mentioned, we had one about a kick, but there's also another question, and it says, please, can you clarify what would come under expenses for a sponsor? Would this include things like mileage, or does this refer more to sponsorship costs?
So predominantly more in relation to sponsorship costs, but I think there are issues also around, and there has been rule change around what you can count towards salary. So when looking at whether or not an individual has achieved the relevant salary threshold in order to be eligible for sponsorship, the Home Office and UKVI have tightened up on what are genuine expenses versus what might we be attempting to add on in order to boost people's pay to make it look as if it's over the threshold. So those aren't the expenses in that respect is not what's being referred to there, but that is something to be mindful of. I think they are focused more in relation to what I was making on the sort of sponsorship costs, but I think it is essential that you are keeping an eye on both, particularly in light of what the current rules say and what that's going to mean for your particular sort of employees. But when looking at salary, what they're looking at is guaranteed base pay. So bonuses shouldn't be counting towards salary threshold. If you've got enhancements for working overtime that will vary, that should not be counting towards your guaranteed base salary. And things like expenses also shouldn't be counting. But yeah, they are tightening up on what you can and can't do to make it more challenging.
Anyway, thank you very much indeed, everybody.
Thank you all. Bye-bye.